Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here today. I just have a couple of areas of interest to me, at least. The first one has to do with your remarks earlier in the hearing where you were drawing the distinction between state court and federal court, and you were saying that state court is, quote, another jurisdiction, state, quote, prosecutors are independent. Third remark, prosecutors are completely independent. Fourth remark, action decisions of the state prosecutors are independent and they are taken of their own volition. What disturbs me about those assertions is what actually happened. I'll go with the Fannie Willis case first, and it just mentioned that her friend spent some 8 hours in the White House discussing the case, her friend, Fannie Willis's friend. And my question to you is, if they're so independent, why were people who were involved in this state action up talking to the federal folks? How do you explain that?
Well, I don't know if it's true. I don't know anything about that. I don't know if she was there, what she was talking about. I don't know anything to support this allegation at all.
I think what I have here on my notes are, were you aware that the Fulton County DA, Fannie Willis's office, coordinated with Special Counsel Smith, the Biden White House, and the Democrat-run January 6th committee during her investigation of President Trump? You're saying you don't know anything about that?
Yes, I don't know anything about that, no.
Would it disturb you if that actually happened?
Well, I imagine that if this committee asks a prosecutor for information, or if a prosecutor asks this committee for information, there may be conversations about that information. I think that is relatively routine. I don't have any idea whether there were any conversations with the special counsel, but it would not be anything wrong with people in different jurisdictions who have evidence obtaining the evidence.
Were you aware that DA Willis hired her friend Nathan Wade to prosecute President Trump as Mr. Wade met with the Biden White House on 2 occasions for 8 hours?
I don't know anything about it.
Again, would that disturb you? And the reason I'm asking this is because it appears that there is this double standard. Some people refer to it as a two-tier system. That is, one tier for certain people like President Trump and the other tier for everybody else. And that disturbs me. Would it disturb you if there was a different type of justice being applied to our former president than that which is applied to other defendants?
Of course it would disturb me. There's only one tier of justice. We treat like cases alike. We don't give any benefit to a powerful person over a non-powerful person, any benefit to a Democrat over a Republican.
I'm not concerned about the defendants getting the benefits so much as I am the prosecutors in the state court coming to the federal folks and basically saying, hey, we know you've been doing all this work here, give us all this material. Now, maybe that much is fine, but that isn't what generally happens. Now, if you were a former president, you're going to get a lot of attention, and that's exactly what's been happening here. And I don't think that's fair. I don't think the people of the United States think it's fair that a former president would be ganged up on, if you will, by both the federal government and the state government. That does not seem right. I mean, you may be doing it, and I guess you're saying that it would be fine if that did happen. But to me, it seems like a double standard. I want to shift over to the audio tapes. And you're a former judge, so you're very familiar with the best evidence rule. It's Rule 1002. And I went to law school. I remember the discussions about, quote, best evidence, but you would know it far better than I. You must have dealt with it literally hundreds of times. But the best evidence rule to we rural practitioners of country law meant that if you had one piece of evidence, well, I know, an audio tape, you'd be far more likely to want to use it, and perhaps it would be required as opposed to a transcript. Is that correct?
I respect your experience, but I'm afraid the best evidence rule is not applicable. Best evidence rule is reflected in Rule 1003 of the Federal Rules of Evidence, and it provides that a duplicate is admissible for all purposes as an original unless there is a genuine dispute about its authenticity. For the reasons I've stated extensively in answers to the other members, there is no genuine dispute about the authenticity of the transcripts. So the best evidence rule simply has no application in this case.
So actually, I would agree with you in the sense that we're not in federal court, and but I also want to tell you that when the essence of his decision, Mr. Hurst's decision, was that there was a challenge that our president is facing when it comes to his memory and his demeanor, then I have to agree with the gentleman from North Carolina that the audio tapes are the best evidence of exactly how how qualified Mr. Herr was in making his decision that he should not prosecute. With that, I see my time is exhausted.